There is a contract between two parties, and one of the parties is claiming that the other party had breached the contract or a particular term in the contract. How do courts determine whether a breach had actually occurred? That's what we will be looking at in this video. So the courts, what they do is they examine two main elements. And the elements, you can see them highlighted on the screen in front of you: the time element and the standard of care. When it comes to the time element, the courts specifically look at the obligation, the time of performance of the obligation. When should that obligation be performed? Is it expressly mentioned in the contract, or would the court have to make an assumption on the delivery of that obligation? Standard of care, the court would need to determine whether it was a strict absolute liability versus an all reasonable endeavors. So these are the two main elements that we'll be examining in depth. Let's start off by looking at the time aspect. So when it comes to time, most contracts would specify a specific date for project deliveries. So you have a contract between the principal and the builder, and it's agreed that the builder has to develop the project and deliver that project to the principal within a 24-month period. Now that is where you'd have an express delivery date specified in the contract. In some cases, however, it's not mentioned in the contract when the delivery is expected. Now, in these cases, what the courts do is that they assume that the project were to be delivered within a reasonable time period. The case that's highlighted over here in the screen in front of you, an English case, is one that demonstrates the importance of the time element to determining whether a breach had occurred or not. To summarize this case, basically you had a person that was selling a property, and the contract had specified that the purchaser was to make a deposit within a specific time frame. So it was explicitly mentioned in the contract that time was of the essence, and that's very important. So it's a strict performance. You have to abide by that specific time period that's mentioned. But however, the purchaser was 10 minutes late. So it wasn't like the purchaser was 1 day late or a week late. The purchaser in this case was 10 minutes late and was thus deemed by the court to have breached the contract. Why is that again? It's because it was mentioned that time was of the essence and they breached that condition. As a result, the courts deemed the purchaser to have breached the contract. So it's very important that when an express date is specified in a contract, both parties have to abide by that express term that's made. Most contracts, you'd expect that the parties involved would have to perform something in return for receiving or for fulfilling the obligations that they desire. So, if I have a contract with a builder, they have to deliver a house for me, and in return, I have to pay them back for that house. So it's a promise from both sides of performing something. There are instances, however, where you have independent obligations, and that's when time can become tricky, especially when you're determining whether a breach had occurred or not. Now, to solve this issue, uh, the the law introduced this act, so a statute, the Sale of Goods Act, and that's specifically to target the aspect of time when it comes to independent obligations. What's an example of an independent obligation? Well, in construction, let's say you're building a particular house and you need material deliveries. Suppliers deliver these materials. Now, the supplier can ask for you to make a payment before they deliver the material. So over here, they're receiving the promise from your end without them fulfilling their promise yet. So this can happen, and it's because that contract that you would have with the supplier is classified under statute as a sale of good contract. And in this case, you can't say that the supplier had breached the contract because they still haven't delivered the material for you yet. Even though you made the payment beforehand, under the statute, this is allowed. So you can't claim that the supplier had breached uh, the condition in the contract. So that was for independent obligations. Now that doesn't usually apply for other aspects in construction. Say for instance, progress claims. You have to deliver something in return for the payment that you receive. So it's just for a sale of good contract where you would classify the obligation as an independent one, and hence you can't claim that the other party had breached because they failed to deliver the project specifically when you paid them the money. Now, of course, if the supplier mentions that they will deliver the materials to you in 30 days time and they take 60 days, in this case there is a breach of a contract over here, because they did mention that it was in 30 days time after they receive the payment they will deliver you the material, but they took longer, so you can sue them for that breach. Okay, so this was just for the time element. The second element that we mentioned at the start of the video was the standard of care. So would the court classify the standard of care as a strict liability? Is it absolute, the promise that was made by the promisor? Was it specified to be performed in a particular fashion? Or was it an all reasonable endeavors standard of care? So in an all reasonable endeavors standard of care, what the court would do is they would look at how hard the party tried to fulfill their obligation. And if it was deemed that they tried their best to fulfill their obligation, but they still couldn't deliver what they promised, then under the all reasonable endeavors, they wouldn't be liable for a breach. Whereas if you look at the strict liability standard of care, this is when, even if they tried their best to achieve the promise and they failed to do that, given that they failed, they will be deemed to have breached the contract. An important case highlighted over here in the screen is Tramways and Luna Park. That's an Australian case. And in that case, what happened was Luna Park had a contract with Tramways for advertising purposes. And it was specified that, the advertisement was to take place for 8 hours each day. Now, on average, it wasn't 8 hours. Sometimes it was less, sometimes it was more. And Luna Park, in this case, was able to sue Tramways because they were considered by the courts to have breached that agreement. So it was a strict liability in that case, and Tramways had breached that strict liability. Okay, so when it comes to building contracts, would you classify it as a strict liability or an all reasonable endeavors? It can be both, and that's why it's important to expressly specify that in the contract. The general test that's adopted by the courts, and you can see it in front of you. So the courts would ask, does it objectively appear that the promisor promised a result? Did they specifically say that we will deliver, let's say, for example, 24 units for you? Or was the promise merely based on a requirement to perform? So if it's a strict liability and they promised you to deliver 24 units, if they do deliver 23 units, no matter how hard they tried with council approvals, etc., they couldn't get it. They promised to deliver 24 units, they only delivered 23 units. In this case, they'd be liable for the breach. If it's merely based on a requirement to perform, then the courts can deem their the efforts in trying to perform that obligation. So they've been trying really hard to deliver 24 units, but because of council approvals, they just couldn't happen. Then in that case, the courts wouldn't classify that as a breach. So it's important to understand the distinction between these two main elements.